The President, please be seated. The court is now back in session. I now hand over the floor to the defense team for Nguyen Chia to resume his closing statement. You may proceed. Thank you, Mr. President. I shall now resume my closing statement. It will take approximately 1 hour from now for me. Your Honors, Mr. Nguyen Chia asked whether this chamber recall that he was the Deputy Secretary of the party in political power. If he had that authority, people from many other departments would have sent him documents. Actually, he did not ask for them, and he did not always see those documents. Certainly, he was not directly in charge of every entity that sent them. My blunt question would be whether the Vice President of the United States or Vice President of a state in charge of every government department that forwards him a memorandum. The confession themselves are proof of nothing. I would invite the chamber to observe that with only one exception, none of the confession presented by the prosecution contain any identifying information aside from the very bare fact that a copy was sent to Brother Nguyen. All of the important questions are left unanswered. Why was that copy sent to Nguyen Chia? Who decided that that copy should be sent? Was the person who sent it correct in thinking that Nguyen Chia wanted to or was supposed to see it? And did Nguyen Chia ever receive it? Your Honors, Nguyen Chia has already given some answer to some of these questions. As he explained in a videotape statement on the case file, he used a small number of confessions for the purpose of education. 35 years later, he does not remember exactly which ones. But that does explain why some small sample of the confessions may have been sent to Nguyen Chia. That explanation is much more consistent with the documentary evidence than the prosecution's outlandish claim that he was directly involved in S-21. The co-prosecutors have also previously observed that 13 out of the 25 confessions that were allegedly sent to Nguyen Chia appear to concern a single military unit. It is far more likely that these confessions were sent to Nguyen Chia not because they happened to have come from S-21, but because they all had to do with a military unit in which, for some reason, Nguyen Chia has long forgotten he had some interest. And indeed, the co-prosecutors have previously taken exactly that position. They have argued that the reason these confessions were sent to Nuon Chea is that he, I quote, had a role relating to the military and regarding to the purge of this unit, unquote. That is a quote at page 59 of the transcript of the 27th of June. Now, Your Honors, to be absolutely clear, Nuon Chea does not concede his role in any purges, in a military unit, in the Central Zone, or otherwise. But we bring this to your attention to point out that even the prosecution cannot come up with a consistent explanation for why they think these documents were sent to Nuon Chea. Were they sent because they came from S21 and Nuon Chea had a role at S21? Were they sent because they were about a military unit in the Central Zone and Nuon Chea was involved in that military unit in the Central Zone? Or were they sent for some other reasons? The documents do not say. The prosecution does not know, and this chamber is unable to decide. The co-prosecutors then claim that Nuon Chea told Tet Sambat, quote, that he received so many confessions that he could not read them all, unquote. This is simply false. What he actually told Tet Sambat was that it would not have been possible to read all of the S21 confessions because too many of those confessions existed. He never admitted to receiving those confessions, and as the evidence shows, he did not receive those confessions. Unable to prove anything of substance through Nuon Chea's receipt of S21's confession, the co-prosecutor claimed that Nuon Chea's role at S21 is established by the annotation he supposedly made on those confessions. And the co-prosecutor claimed that 6 confessions in evidence contain annotations made by Nuon Chea. Your Honors, let me begin by examining that claim at face value. Mr. President, let us assume just for a moment that Nuon Chea annotated 6 S21 confessions. What would that show about Nuon Chea's role at S21? It would simply show that he had almost no role at all. It would show that of the 4,183, say counsel, confessions on record, Nuon Chea did not annotate 4,183 of them. Is this the keen interest in S21. This chamber has heard testimony that staff members were working at S21 reviewing documents as early as the summer of 1979. Leading actually yet even this allegation that Nuon Chea annotated all of the 6 S21 confession is unsupported by any evidence of any kind. Indeed, the evidence that Nuon Chea annotated these 6 confession is so preposterously weak that the co-prosecutor continued effort to rely on it is perplexing and a telling indication of the quality of evidence against Nuon Chea. The co-prosecutor repeatedly claimed that Deutsch has identified Nuon Chea's handwriting on S21 confession. Is that true? What is Deutsch's actual testimony about those annotations? His actual testimony was that during Democratic Cambodia, the confession he sent to his superiors were never returned to S21. Hence, the first time he ever saw an annotation on an S21 confession was in April 1999, when it was shown to him by Nat Thayer. His testimony in that regard was very clear, and let me read you a short excerpt from Deutsch's testimony before this chamber on the 4th of April 2012. Question. Just to be sure about the date, when did you first see confession annotated by your superior? Answer. That was in April 1999. That was on page 82 of the 4th of April transcript. So Deutsch has admitted that he had no contemporaneous knowledge from the Democratic Cambodia period of any annotation on any S21 confessions. In fact, he explicitly told the investigating judges that he was unable to identify Nuon Chea's handwriting. When the investigating judges showed Deutsch one of the 6 annotations that the co-prosecutor today say were made by Nuon Chea, Deutsch stated as follows, and I quote, I don't know who wrote that, but it was not that of Pol Pot, whose handwriting was similar to mine, like Son Sen's and Von Waite's. Perhaps Nuon Chea wrote it, but it was just my assumption, because I did not see his handwriting often. End quote. That was in one of Deutsch's interview with the investigating judges. It is document E3/355. In spite of this clear evidence that Nuon Chea had no role at S21, the co-prosecutors claim that Nuon Chea admitted that role to Tet Sambat. That claim is demonstrably false. Not once in Tate Sambat's more than 1,000 hours of audio and video recordings of Nuon Chea did Nuon Chea make any such admission. Nuon Chea spoke to Tate Sambat candidly for years. They discussed the issue of so-called enemies extensively. They even discussed S-21 confessions. Through all of these discussions, Nuon Chea never stated, hinted, or suggested that he was Dutch superior at S-21. That is compelling evidence that no such relationships existed. The co-prosecutors claimed that one single paragraph from Tate Sambat's book entitled Behind the Killing Field constitutes an admission that Nuon Chea supervised S-21. Yet, in the paragraph they cite, there is one very important thing missing: an actual statement from Nuon Chea. What that paragraph contains is only the opinion of the authors. Tate Sambat's book is filled with the supposed direct quotes from Nuon Chea. There are dozens of them, maybe hundreds. Yet in the paragraph which the co-prosecutor says constitute an admission from Nuon Chea about his role at S-21, there is not a single direct quote from Nuon Chea himself. I ask the chamber to consider the following. If Nuon Chea had admitted to Tate Sambat that he had had a role at S-21, the notorious crime site in the Democratic Cambodia, would Tate Sambat not have clearly said so? If Nuon Chea had told Tate Sambat that he had a role at S-21, would that supposed admission not have found its ways into enemies of the people? Obviously, it would have. But it did not. And why? Because it never happened. If the chamber verifies the sources relied upon in Tate Sambat's book, it will find that their source is one very familiar to this chamber. Their source is Deutsch's testimony in case 001. That testimony is, of course, in evidence, and we will deal with its probative value momentarily. But the excerpt cited from Tate Sambat's book does nothing more than recycle that testimony. For this reason, it is of no relevance or probative value. Having found no documentary or physical evidence of Nuon Chea's role at S-21, the co-prosecutors tried to prove that a role circumstantially. They argue that Son Sen, who was initially in charge of S-21, was dispatched to the East Zone in August 1977 to deal with the military conflict with Vietnam. They imply that because Son Sen was no longer in Phnom Penh, he could not have continued to supervise Dutch. Yet the co-prosecutors failed to mention that multiple former S-21 guards who worked at S-21 every day specifically told the investigating judges that they personally saw with their own eyes that Son Sen come to S-21 right up until the Vietnamese entered Phnom Penh in January 1979. None of these witnesses testified in case 002/01 because S-21 is not a part of this trial. This is a perfect example of why the Chamber may not make findings with regard to Nuon Chia's role at S-21 in case 002/01. Son Sen's presence at S-21 after August 1977 is a question of critical importance in relation to Nuon Chia's alleged responsibility. The exclusion of this evidence from this trial was a self-imposed restriction decided upon by this chamber. Having decided not to hear this critical exculpatory evidence, the chamber cannot now find, beyond a reasonable doubt, that Nuon Chia was responsible for S-21. And I will note for the chamber that we have previously argued that this specific fact, whether Son Sen was present at S-21 throughout 1978, was one reason why this chamber may not make findings of fact in relation to S-21 in this trial. We made that argument in document number E284/4/1. The only evidence left that Nuon Chia had a role at S-21 is in Dutch's uncorroborated claims that he reported to Nuon Chia. There are numerous reasons why this testimony is unreliable and cannot be accepted by this chamber. First, as I have just shown, it is inconsistent with all of the documentary evidence. It is inconsistent with the evidence that Nuon Chia received only a very small number of S-21 confessions. It is inconsistent with the evidence that Nuon Chia's messengers, whom Dutch says were responsible for delivering S-21 confessions to Nuon Chia, delivered those confessions very rarely. It is inconsistent with the evidence that Nuon Chia made no annotations on any S-21 confessions, a fact conceded by the co-prosecutors, except as to 6 lonely documents. It is inconsistent with the testimony of S-21 guards who indicate that Dutch superior Son Sen was at S-21 regularly through the entirety of the DK regime. Second, Dutch consistently proved willing to make outlandish claims about the senior leaders of the CPK. As we described at paragraph 120 of our brief, Dutch frequently spoke as if he had first-hand knowledge of the responsibilities of CPK senior leaders when in fact he was in possession of no such information. That is specifically true in relation to Dutch claim about Nuon Chia's role at S21. As the co-prosecutors observed, Dutch repeatedly testified that he was able to identify Nuon Chia's handwriting on confessions and other documents. Yet, as we have already shown, Dutch sheepishly conceded on cross-examination the very first time he saw the annotation of a senior leader on an S21 confession was in April 1999.
Third, Dutch has always had and continues to have a substantial interest in deflecting responsibility for his acts during democratic Cambodia. The notion that Dutch reported to Nuon Chea and was required to appear at his office on a regular basis conveniently serves his interest in claiming that he was just following orders. It is crucial to recognize that if Dutch did not report to Nuon Chea after Son Sen took control over military operations in the East Zone, it would follow that he was left to make semi-independent decisions with minimal supervision. From Dutch's perspective, responsibility lay either with Nuon Chea or with himself. We are not surprised to find that Dutch picked Nuon Chea. In case 001, the Supreme Court chamber recognized that Dutch's testimony was unreliable precisely because of his tendency to blame others rather than accept responsibility himself. In the case 001 appeals judgment, the Supreme Court chamber held as follows, and I quote, Kang Gek-il failed to offer a complete picture of his factual knowledge of this case in order to minimize his role in the crimes. He carefully avoided responding in full when confronted with allegations related to this personal involvement, seeking to attribute the responsibility for the crimes to others, and uttered statements which are inconsistent with available evidence. End of quote. Fourth, despite these obvious problems with Dutch's credibility, this chamber repeatedly prevented the Nuon Chea defense from exploring questions of direct relevance to his credibility during cross-examination. As we explain in detail in our brief, and will elaborate upon later today, the chamber made a series of unreasonable and baseless rulings in the course of our cross-examination. Those rulings prevented defense counsel from showing Dutch admissible documents which directly contradicted his testimony, and which would have further diminished his already doubtful credibility. The chamber gave no reasons for these rulings and repeatedly interrupted defense counsel, including by turning off our microphones when we tried to ask relevant and admissible questions. As we demonstrate in our brief, the chamber later reversed these rulings, again without reasons, permitting the co-prosecutors to do that which it had not allowed the Nuon Chea defense to do during its examination of Dutch. Now I'd like to touch upon the supervision of zones and autonomous sectors. Mr. President, I will now address the co-prosecutor's claim that Nuon Chea, and I quote, was responsible for monitoring and directing the implementation of the party political line by all zone, sector, and party organizations, end of quote. Nuon Chea does not dispute this assertion outright. Indeed, he agrees that standing committee policies were implemented by zone-level officials. He also agrees that the standing committee monitored the extent to which their high-level objectives were being made. It is, however, not accurate that Nuon Chea, and I quote, directed, end of quote, the implementation of those policies. His ability to monitor zone-level implementation was similarly limited and dependent on the cooperation of zone-based officials. The co-prosecutors alleged that Nuon Chea supervised the zones in 3 ways: by holding meetings with zone and sector leaders in Phnom Penh, through his receipt of telegrams and reports, and by making trips to the provinces. In each of these respects, the co-prosecutor's characterization of Nuon Chea's role is incomplete and misleading. The co-prosecutors have not presented sufficient evidence to establish that supervision beyond a reasonable doubt. Now, on the issue of meetings. First, I will address the claim that Nuon Chea met regularly with zone and sector level officials. As the co-prosecutors note, Nuon Chea did hold meetings with key zone leaders, especially Tam Mok, Sao Phum, Ruh Nhim, and to some lesser extent Kai Pok. Nuon Chea does not recall exactly how often those meetings took place, but estimates they took place several times each year. Nuon Chea reminds this chamber that all 4 men were members of the standing committee. It was in that capacity that they traveled to Phnom Penh for meetings with other members of the standing committee, including, among others, Nuon Chea. They did not, however, come to Phnom Penh to report to or receive instructions from Nuon Chea. They came to discuss matters of importance to their zone and the country in their capacity as members of the CPK's highest governing body. Nuon Chea respectfully reminds the chamber that the co-prosecutors continually assert that the CPK governed through, and I quote, collective decision-making, end of quote. According to the co-prosecutors, collective decision-making meant that Pol Pot did not issue orders to Nuon Chea, but rather discuss CPK policy until an agreement was reached. This was equally true of Pol Pot's relationship with powerful zone leaders. Zone leaders had their own power base within their respective regions and controlled significant military forces. The Standing Committee could not and did not issue detailed orders to zone leaders. They agreed on broad policy outlines which were implemented at the whim of zone leaders. That was the nature of the meetings between zone leaders, especially Tamok, Sopem, and Ruhnyum, and the other members of the Standing Committee who were based in Phnom Penh. Nuon Chea also occasionally met with secretaries of the autonomous sectors. Autonomous sector secretaries were not members of the Standing Committee and had less power than the zone secretaries. They came to Phnom Penh far less often and only when a specific matter was in need of discussion. Nuon Chea did not meet with other officials, including non-autonomous sector and district-level cadres. Instead, these cadres came to Phnom Penh only to participate in large political gatherings. Nuon Chea cannot recall any single instance of meeting in a smaller group with officials at that level. If that did happen, it was a rare and exceptional occurrence. The evidence strongly supports Nuon Chea's account. The evidence cited by the co-prosecutors, which I will review in detail momentarily, shows that Nuon Chea met only with zone and autonomous sector secretaries. The minutes of Standing Committee meetings in evidence reveal that an aggregate of 3 cadres from any part of the national administrative structure attended any of the 19 Standing Committee meetings on record. Only one witness from within the national administrative structure testified that he participated in any meetings with the senior leaders in Phnom Penh. As the co-prosecutors note, that witness was Sao Sarun, the Secretary of Autonomous Sector 105 for more than a year. Over that period, Sao Sarun participated in only 3 meetings. Each of those meetings had a specific purpose. The first followed the death of his predecessor, that is Talang. The second was for the purpose of formally appointing him Secretary of Sector 105. Only once over the course of more than 1 year did Sao Sarun travel to Phnom Penh for the purpose of discussing developments within the sector. Sao Sarun's evidence, therefore, shows that autonomous sector secretaries did not attend regular meetings or even occasional meetings in Phnom Penh. 3 witnesses cited by the co-prosecutors described standing guard at K1 and K3 during meetings between zone-based officials and senior leaders based in Phnom Penh. All 3 witnesses testified that they did not recognize any of the zone-based officials whom they saw attend meetings at K1 and K3. They were accordingly unable to testify as to their identity. The The chamber can find the testimony of the first witness, Savi, in the 8 January 2013 transcript at pages 23 through 25. And it can find the testimony of the second witness, So Tương, in the 18 April 2012 transcript at pages 53 through 54. The third witness, Eun Tan, testified that it was the same small group of individuals who attended all of these meetings. The chamber will find that testimony in the transcript of 13 June 2012 at page 53. That testimony proves that Nuon Chea was not meeting with a rotating group of cadres at different levels of the CPK hierarchy. Instead, he met with the senior-most leaders of each zone and autonomous sector, most of whom were themselves members of the Standing Committee. Other evidence cited by the co-prosecutors is consistent with these conclusions. The co-prosecutors gathered this evidence at footnote 1846 of their brief. Pin Kien indicated that meetings of the zone committees took place annually at K3. Nuon Chea believes that Mr. Pin is mistaken, but does not deny meeting with zone leaders. This disagreement is therefore immaterial. Kampan, TCW 596, and document E3/366 all testified before the co-investigating judges that the Secretary of Autonomous Sector 105 traveled for meetings to Phnom Penh. That testimony is equally consistent with Nuon Chea's assertion that he met only with zone leaders and autonomous sector secretaries. P. Poon's statement concerns a meeting in May 1975 with zone and autonomous sector secretaries. Nong Supong testifies that zone leaders attended meetings in Phnom Penh. Mr. Nong, a telegram decoder, does not explain how he knew that the habits of zone leaders. His testimony is nevertheless consistent with Nuon Chea's claim that he met only with zone and autonomous sector secretaries. Witness E3/464 described attending political education sessions at the Olympic Stadium and Borei Keila with hundreds of cadres. Nuon Chea readily agrees that he delivered political education at large gatherings. Prak Yut confirmed that district-level cadres in the southwest zone did not attend meetings of any kind in Phnom Penh. Now on the issue of telegrams and reports. Second, the co-prosecutors assert that Nuon Chea supervised activity in zones and administrative structures through his receipt of telegrams and reports. However, Nuon Chea's receipt of telegrams concerning activity in the zones is not at all probative of his supposed supervision. To begin with, the co-prosecutors are correct that Nuon Chea received telegrams and other communications only from zone and autonomous sector secretaries. That means that Nuon Chea had no direct communication from Phnom Penh with any cadres below the leadership in each zone or autonomous sector. That means he was told only what the zone leadership knew and only what they wanted him to know. In fact, the evidence conveyed to Nuon Chea by the zone leaders was systematically inaccurate. As we demonstrated at paragraph 203 of our brief, cadres overstated production results and downplayed work hours and executions. The co-prosecutors have shown only that reports were regularly sent to the senior leaders of the CPK. They have not shown that these reports were accurate. And in fact, they were not. Furthermore, Nuon Chea almost never responded through these telegrams. He did not supervise the base in any substantive way because he provided no instructions about how they should implement the vague political lines of the party. The co-prosecutors claim that Nuon Chea did respond to these communications and issue instructions to zone leaders is incorrect. The only evidence they cite in support of that claim is the testimony of telegram decoder Nong Sopong. In reality, Nong Sopong testified before both the co-investigating judges and this chamber that he very rarely sent outgoing telegrams from Nuon Chea. In his testimony before this chamber, he recalled doing that only twice over 4 years. He also testified that usually they concern the delivery of goods requested by zone-level officials. I will respectfully direct the Chamber through our brief at paragraph 204 in that regard. The Chamber will find similar testimony if it verifies the reference to Nong Sopong's statement provided by the co-prosecutors at footnote 1863 of their brief. On the issue of trips to the provinces, third, the co-prosecutors claimed that Nuon Chea supervised the zones through his trips through the provinces. As a preliminary matter, we note that most of the evidence cited by the co-prosecutors shows nothing at all about Nuon Chea's so-called supervision over the zones. Notably, it shows that Nuon Chea met mainly with zone and autonomous sector secretaries, which is again consistent with his account. It also purports to show that Nuon Chea knew that CPK policies were causing hardship to people at the base. Nuon Chea strongly disputes that. But for these purposes right now, I will emphasize that this fact is irrelevant to the question that the co-prosecutors say that it relates to. Even if it were true that Nuon Chea witnessed hardship at the base, which it is not, that would have no bearing at all on his ability to supervise the zone-based cadres. Next, the co-prosecutors described political education sessions given by Nuon Chea in various base areas. This is at paragraphs 479 through 482. This is yet again consistent with Nuon Chea's evidence that he met only with zone and autonomous sector secretaries. He interacted with other cadres only through large political education sessions, in which he articulated the general political line of the party. The co-prosecutors tried to make these speeches more relevant to Nuon Chea's supposed supervision of the base by identifying two specific instances in which a series of arrests were made following a speech given by a member of the CPK. These two events include a speech in Sector 103 in Preh Vihear and one in the West Zone. We are not sure exactly what the relevance of this claim is supposed to be. We assumed the co-prosecutors are urging the chamber to conclude that there is some causal link between the speech in question and the arrest, which allegedly followed. Yet the evidence manifestly fails to prove this. To begin with, in one of the two examples put forward by the co-prosecutors, the speech in question was not even given by Nuon Chea. And that evidence is not someone other than Nuon Chea gave a speech, nor there is evidence of any connection between the speeches in questions and the arrest which allegedly followed. I would ask the chamber to record that, according to the co-prosecutors, hundreds of thousands of people were executed at hundreds of security centers across Cambodia. They also assert that Nuon Chea regularly delivered political education to cadres at the base. Yet they are able to find a single example of a single instance in which a sequence of arrests followed a speech given by Nuon Chea. The co-prosecutors tried to link Nuon Chea to the arrest in Preh Vihear in the West Zone by claiming that Nuon Chea annotated the confessions of certain cadres allegedly arrested in the course of those purges. We have already dealt with these confessions. We have shown the chamber that there is no basis whatsoever on which to conclude that Nuon Chea annotated these documents. This evidence must, accordingly, be rejected fully and completely. Thank you, Mr. President. President, thank you, Counsel, for the defense. The time is appropriate for today's adjournment. The Chamber will adjourn now and will resume on Thursday, the 24th of October 2013, commencing from 9 a.m. And the Chamber would like to inform the parties and the general public that the proceeding on Thursday, the Chamber will cede the floor to Nuon Chea's team again to continue their closing statements in case 002/01. This information also applies to the support staff. And tomorrow is a national holiday. That is the 23rd October 2013. Security guards joined strategy to take the accused Nuon Chea and Khieu Samphan to the detention facility and have them return to participate in the proceeding on Thursday, the 24th of October 2013, before 9 a.m. Khieu Samphan shall be brought to the main courtroom, and Nuon Chea shall be taken to the holding cell downstairs, which is equipped with audio-visual equipment for him to participate in the proceeding remotely. The court is now adjourned.
សូមអញ្ជើញក្រោកចុះ